Gentlemen, thank you, ladies and gentlemen, thank you for joining our webinar this afternoon. It looks like there are a couple of new faces in the audience, which is always welcome, so thank you for joining. Today we are addressing the question of how India's Insolvency and Bankruptcy Code is reshaping recovery outcomes for credit investors. There will be a short presentation by the panelists, followed by some Q&A. If I could ask the audience to keep their questions until the end. You may raise your hand and we will unmute you. Alternatively, you may post your questions in the chat. India's private debt market is still very, very small, but it is growing rapidly. Assets under management have grown roughly 25-fold since 2010 to an estimated 25 to 30 billion, with a record 12.5 billion deployed across 166 transactions in calendar 2025. That's a 35% growth over the prior period. And projections are for 60 to 70 billion in AUM by 2028. Yet this still represents barely 0.6% of GDP and 1.2% of corporate lending against a backdrop of structural underpenetration of credit itself. India's credit to GDP ratio of roughly 57% compares with 126% for Vietnam and over 200% for the United States. The market is in effect a deep reservoir behind a narrow sluice gate. The constraint has historically been institutional plumbing and not demand. For international allocators, the case as a diversifier is threefold. Returns are driven by domestic demand and bank disintermediation dynamics, which are largely uncorrelated with US credit cycles. Managers have historically been achieving IRRs anywhere between 9 and 15% in US dollar terms for performing credit and 15 to 21% in high yield. What changed the sluice gate's width and what makes these returns underwritable at all is the legal infrastructure for creditor rights, which brings us to the Insolvency and Bankruptcy Code. To help us understand this better, I'm delighted to welcome Ashwin Bishnoi, Senior Partner at Caton & Co. Caton is one of India's oldest and largest full-service law firms, founded in 1911 with over 1,300 lawyers across 7 Indian cities, and which is consistently ranked among the top tier by Chambers Legal 500 and other leading global directories. Ashwin Bishnoi is one of India's leading lawyers in corporate insolvency, restructuring, M&A, and private credit, with nearly 2 decades of experience across India, New York, and London. He previously spent 4 years in Skadden's restructuring practice and has been at the forefront of India's modern bankruptcy regime, including contributing as a peer reviewer to the Bankruptcy Law Reforms Committee that drafted the Insolvency and Bankruptcy Code 2016. Engaging in conversation today with Ashwin is Sudhita Dor, co-CIO and senior partner at Alpha Alternatives Singapore. Alpha Alternatives, for those of you not yet familiar with our company, is India's premier alternative investment platform with a clear mandate to be asset managers, not asset accumulators. Founded in 2013, our investment teams manage over $3 billion of assets across both public and private strategies. Sudhita Dar has over 2 decades of experience in the financial sector. He is an expert in structuring, credit evaluation, and portfolio management. Previously, Sudhita worked as the Deputy CIO of GCS Capital Management, and before that as a director at Merrill Lynch. Earlier in his career, he worked at various other leading financial firms in India like Citibank and ICICI Bank. He is a graduate of St. Xavier's College, Calcutta, and has completed his post-graduation in management studies from IIM Ahmedabad. Sudhita, can I turn to you first to start our presentation?
Sure. So Ashwin and I will just take a few minutes to run you through the presentation, then we move to the Q&A. So just moving on quickly, I don't think you can understand the IBC without understanding the context in which it was actually enacted. In 2016, when this act was enacted, the banking system NPAs were running at around 10% plus. There were a lot of stranded assets. There were these big power plants, 500 megawatt, 750 megawatt power plants, which were not operating at capacity or not operating at all. And there were these laws which were supposed to help lenders restructure and solve these problems, but they weren't quite working the way they were supposed to. So there was no credit flowing through the economy. So the government was very clear that they needed to sort out these problems because it was a fundamentally an India problem, not just a lending banking sector problem. So that point of time, the IBC was enacted. And if you look at the preamble of the IBC, there are 5 or 6 things mentioned, but primarily these were the three things that the Act was really trying to achieve. Number one was that they wanted a resolution to the problems within a time-bound manner, right? These things were taking ages. Number two is that they wanted to maximize asset value. There was a lot of value trapped in these companies, which were worth probably much more as a going concern rather than in liquidation. They wanted to maximize that. And third thing was, most importantly, was they wanted to promote what they call entrepreneurship, which basically was having a lot of promoters who didn't know how to run their companies out, bring in a new lot of promoters who could take over these assets and start operating them at efficiencies which made sure that the economy was growing appropriately, right? So moving on from there, what did this really mean for the legal regime? What did the IBC bring in? There were 3 or 4 things which I just want to cover quickly. Number one was that there was a single unified framework now which was used for enforcement and for resolution. Previously, there were various acts like the Sikh Industrial Companies Act, there was a SARFAESI, all of which were used to enforce on certain types of collateral, but there was no unified code which was doing that. So the IBC stepped in to do that. Number two is that it changed how the companies were controlled once they were in restructuring, right? So the previously what used to happen is that the promoters of the company would continue to operate the company, and so there was every incentive for them to asset strip, to do related party transactions, take cash out of the company. That changed because now under the IBC there was a third party independent resolutional professional who actually came in and took over the operations of the company, right? The third was the timeline. So there were some strict timelines that have been mandated in the IBC. They aren't always met, and we'll discuss that a bit later. But it definitely put in a time-bound system for solving these problems. And the fourth thing that I think it brought in was that there was simple objective measure based on which these companies were being taken to the IBC, which was that you had to establish you had debt, you had established that the debt had defaulted, and then as a lender under Section 7, you could actually go to the NCLT and say, this company is defaulted, and I want to now take it through the CIRP process, right? So what did that mean? If we just look at some of the statistics, previously it used to take about 6 to 8 years to resolve these problems. Now it takes about 2 years from the time that the company goes into IBC, it's admitted to the IBC, to the time that it actually comes out of it, right? There probably takes a little bit, there's a little bit more time taken, maybe 9 to 12 months, which is the time taken for it to actually be admitted to the IBC. But the timelines have improved significantly, right? Recoveries have gone up, they've doubled from where they used to be. And if you look at some of the rankings, and this is, we are using World Bank rankings here, which are actually date back to 2020 because the World Bank hasn't released any since then. India's ease of doing business and its position on the resolving insolvency index actually improved dramatically, right? The other statistic I'll leave you with here is the fact that the NPAs in the banking system, which used to be 10.2% in 2016, are actually around 2.1% today. Not all of it is due to the IBC. The fact that the economy has done well has something to do with it. But the IBC has also contributed substantially to that process, right? So I'll just hand it over to Ashwin here, and he can actually take you through the nuts and bolts of what is actually mandated in the IBC and how does it actually work? How does the process work? So Ashwin, over to you.
Thank you, Sudipta, and thanks, Christian and Sudipta, for having me on board. Um, this is the infrastructure and the 4 key pillars behind the IBC, which is the Insolvency and Bankruptcy Code. This is what gives credit platforms, financial institutions, the comfort behind the workings of this regime. It borrows heavily from the UK Insolvency Code in that once a debtor goes into insolvency, it is managed by an insolvency professional. So, which is why on the left, you will see that there's a whole stakeholder base of insolvency professionals regulated by various organizations, trained with CLE credits. and so on and so forth. Similar to the UK insolvency code, UK insolvency regulations, there is a regulator in India, but we have an actual insolvency and bankruptcy board. The board regulates insolvency professionals to make sure that there is no misconduct. It also writes subordinate legislation, and that's one of the reasons why this law has been incredibly nimble and reactive to changes. Every time a interpretation comes out which is not in line with what the IBC is meant to do, you will see that the IBBI makes amendments, clarifications, regulations to set the agenda pointing north again. All of this folds into a bankruptcy code. The bankruptcy courts in India, there's a dedicated tribunal mechanism. They have two key points of intervention in this process. One is when you open insolvency proceedings, and secondly is when you want to exit by way of approving a resolution plan. And lastly, but not the least, we recognize in India that there is information asymmetry. People don't know whether there's a debt or a default with a particular debtor. So every single dollar of debt and every single dollar of default is supposed to be recorded in an information utility that's on the right. And that in future is meant to make the process of opening insolvency proceedings even simpler, as courts are directed to look at the filings in the information utility and not spend more time in determining whether a debtor is insolvent. So with that, maybe we could go to the next slide.
Yeah.
There are those are the four pillars. These are four key phases of the IBC. One is the triggering mechanism. Second is the actual process of running insolvency. Third is the committee of creditors, how they decide what's the voting thresholds, what are their key roles. And lastly, but certainly not the least, is the actual approval of a resolution plan for exit from insolvency. I'll touch upon each one of them briefly, but the key point to take note of is that under India's insolvency process, in most situations, connected party sales, as you have them in the UK, and debtor in possession plans, as you have them in the US, they do not exist in India, which effectively means that every insolvency process is a hostile M&A opportunity. And that's the CIRP engine that you see in, on the box in front of you with number 2 against it. But with that quick introduction, maybe we double click a little bit on some of these and we can go to the next slide. So how do you actually trigger and open insolvency proceedings? Well, it was deliberately kept very simple. Some jurisdictions like the UK would go into cash flow insolvency determination or balance sheet insolvency determination. We in India, rightly or wrongly, deliberately decided not to do that. And so a simple default is enough to trigger insolvency. If a debtor defaults in payment of $100,000 of debt, that is sufficient to file insolvency proceedings. And that is all that a court is meant to take into account in opening insolvency proceedings. It is for this reason that you've seen that there has been a significant increase in insolvency filings before Indian courts, where a debtor is indeed solvent and able to repay. This is one of the reasons there has also been a significant increase in debtors actually settling before bankruptcy courts and judges begin hearing on insolvency opening. If we can go to the next slide. In the event a debtor is unable to pay a $100,000 payment default, the bankruptcy tribunal is meant to open insolvency proceedings. In doing so, it triggers a moratorium. This moratorium is similar to what you would expect in the US. It is not an automatic moratorium, though judges are meant to in their insolvency opening order, also pass an order that no enforcement action can be taken against the debtor. So the moratorium effectively operates as an automatic moratorium. This moratorium continues till the debtor is resolved, a resolution plan is passed. And if you go to the next slide, you will see what all this states. The moratorium effectively stays all suits, legal proceedings, enforcement actions against the debtor. So that is a shield that is provided to the debtor to maintain its assets. There is also a shield to lenders in that the debtor is stayed from transferring any assets. So no asset stripping is possible. And this is one of the critical benefits. By statutory legislation, all creditors, regardless of where they are located, get the benefit of this shield, as does the debtor. There are some exceptions to this automatic stay. For example, if certain payments are required to be made to continue the debtor as a going concern, those are very critical payments as the bar is high. Those sorts of payments can be made in order to maintain the debtor as a going concern. But there is this quiet period and moratorium that immediately kicks in. Once this is done, you have the committee of creditors that begins to play a very important role. And Sudipta, I'll hand over to you to walk us through what that is.
Sure. So in the slide, there's 2 slides before, Ashwin talked about the fact that the IRP was appointed. So once the resolution professional is appointed, what he does is that he makes a list of all the various obligations that are there, the debt obligations, and identifies which are financial creditors, which are operational creditors. And then the committee of creditors is formed. And there are a few things to note about it, because this is the body that will basically decide as to which resolution plan is approved, or whether all resolution plans are rejected and the company ultimately goes into liquidation. So a few things to note here is that the committee of creditors is made up exclusively of financial creditors. And this does not differentiate between secured and unsecured creditors. But what it does, the group it does actually leave out is the operational creditors. So even the government, if they have certain tax claims, etc., against the company, they would be classified as operational creditors and they are not part of this. And the committee of creditors actually evaluates all these plans which are put in front of it, the resolution plans, and also takes all decisions that are to be taken at that point of time, and requires a 66% threshold for approval of all these decisions, right? At that point of time, there is also a possibility of some sort of out of court settlement where the company actually goes out of the IBC process, but that requires a 90% approval from the COC. And one key thing to note here is that the Supreme Court, through its various case laws, has actually established the fact that the COC's decision is final and it cannot be overridden, right? So what happens when you now come to the end of the CIRP process? The COC has been set up. Various plans have been put in front of the COC. Various people have bid for the assets of the company as a going concern separately, etc. And the COC now needs to decide as to which plan it approves. So once the 66% of creditors or more who form the COC agree that this is the particular plan that they like, that plan is approved by them and it gets its blessings from the NCLT. And then the company comes out of the CIRP process as a totally clean company. So its prior claims on the company, all liabilities, etc., are all extinguished. So if I am a buyer in the IBC process who's buying a company out of the IBC process, what I get is a company free of any liabilities. If there are personal criminal liabilities related to the promoters, those are not extinguished, but the company itself is totally clean, right? And that's very important. The second part of it is what happens if all the plans are rejected by the COC. At that point of time, then the company then just CIRP clock expires and the company goes into liquidation. And there is a certain waterfall that needs to be followed. So I'll let Ashwin run you through that. Ashwin, back to you.
Thanks, Sudipta. So this is the insolvency waterfall. This is the backbone of the IBC. It determines what creditors are likely to receive in an insolvency process. There are some principles to bear in mind, though. While there is an insolvency waterfall set out, the bankruptcy code also requires that the payments to creditors be fair and equitable. I'll explain what that means. Secondly, as Sudipta alluded, India's bankruptcy law is a little different in that it places financial creditors in a much better position than what you would see in the UK or the US. How so? As we've seen, it's easier for financial creditors to initiate insolvency opening. They just have to prove that there is a $100,000 payment default. They don't need to also prove that that default is undisputed, which is what trade creditors need to prove. Secondly, the committee of creditors constitutes exclusively, almost in all situations, only financial creditors. That's because the Indian regulator felt that they have the most dollars at stake, and therefore they get to determine the direction of travel of recovery of a creditor. And thirdly, and this is what you will see here, in the US, there are only two classes of creditors, broadly speaking, secured and unsecured, regardless of what's the color of your debt, whether you're trade or bank or financial indebtedness. In India, a unsecured financial creditor ranks above an unsecured trade creditor. So I repeat, an unsecured financial creditor ranks above an unsecured trade creditor. So with those three principles in mind, let's just look at what this waterfall looks like. Most of it is what you will relate to in other jurisdictions as well. Top of the waterfall is insolvency costs. So costs payable to the insolvency professional, costs of running the debtor as a going concern during insolvency, DIP finance are top of the waterfall. DIP finance in India is a very small end of the market. We don't permit priming as you would in the US. So if you need the consent of the committee of creditors to take DIP finance, it really is not a very big market. Second is secured creditors, whether financial creditors, non-financial creditors, doesn't matter. If you're a secured creditor, you sit in bucket number 2. You share pari passu with some priority workmen and employee dues. And by priority, I mean it's a duration of time. So last 12 months or 24 months dues, similar to what you would see in other jurisdictions. Then come unsecured financial creditors. Then come unsecured trade creditors, operational creditors, service dues, and the likes. Government comes fifth. Most all 99% government dues are bottom of the waterfall. In some instances, you will see government dues climb up the waterfall. For example, in the telecom space, where if you have telecom dues and if you want those telecom licenses to continue, then government dues tend to travel up the waterfall because government due then is critical for the telecom spectrum or license to continue to be available. And bottom of the waterfall is equity shareholders. Now, this waterfall is respected in most all situations, except as you remember, I said that one of the principles is also that the distribution in a resolution plan needs to be fair and equitable. So the code puts on the committee of creditors a onus to make sure that the plan is fair and equitable. This typically would play out as if the financial creditors are getting 90 cents to the dollar, you can't have a situation where the trade creditors at the bottom of the waterfall are getting nothing. That seems a bit lopsided. So you will see some instances where to buy the piece, trade creditors or operating creditors are they receive a small 1% or 2% payout. But in large part, it's the financial creditors who sit way above in the waterfall, and their determination on who needs to pay what is largely respected by the bankruptcy courts, and they do not interfere in the wisdom of the committee of creditors, except for this analysis of whether the plan is fair and equitable. That's on the distribution waterfall. Back to you, Sirta.
Thank you, Ashwin. I think we are done with the presentation part of it.
Yes.
What we'll do is that I'll hand it back to Christian, and Christian, maybe you can start with the Q&A.
Certainly. I want to thank you both, first of all, for a very clear and concise presentation, and also for keeping to your time allocation. It's given me, at least, and hopefully our audience too, a much clearer insight into the architecture and significance of this piece of legislation. Before we take questions from the audience, I have a couple for both of you, if you don't mind, which I'd like to myself start with. Turning to you first, Ashwin, as an international investor and potential creditor in India, can you help me understand or better understand how I would be treated as a creditor in India compared to what I might expect in other jurisdictions in like under Chapter 11 in the United States, for example?
Sure, sure. So, I mean, Christian, um, the Chapter 11 is largely used by debtors in the US.
Hmm.
And so when you consider exit strategies in the US, Chapter 11 is actually something that the debtor uses against creditors in the US. In India, it's quite the reverse. The insolvency process is almost entirely being used by the debt by the financial creditors in order to either recover their dues or restructure the debtor company. And why is that? The US Chapter 11 process is a debtor in possession process. And that means the incumbent management continues, the incumbent ownership continues. In fact, they get the first rights in most situations to propose the first resolution plan. It could not be more different in India. Uh, India has a Section 29A under which, in most situations, the incumbent management and ownership cannot continue cannot continue to manage the debtor during the insolvency process. It is the insolvency resolution professional who replaces the board of directors, and the incumbent ownership and management cannot propose a resolution plan for the revival of the company. So they're out. So them being out means that the bankruptcy code is a strong deterrent. And as someone very famously once said to me, that every religion needs a good hell, because if you have a good hell, is heaven to be aspired for. So the bankruptcy code is a good hell for
Mm.
defaulting debtors, which means it automatically results in a different form of behavior prior to default, prior to insolvency. So that's two critical differences to the US Chapter 11 process. The third one that I would say is, and I briefly alluded to it, the treatment of financial creditors. It's a creditor in control mechanism, not a debtor in possession. So almost all key decisions in an insolvency process and the approval of the resolution plan are taken by the financial creditors in a Indian bankruptcy court. There are there are some nuances about how the voting in the committee of creditors works. In the US, you have classes of creditors, which is why you have the cram down mechanism and the likes. In India, again, in trying to avoid litigation, just like we did by not having balance sheet and cash flow determination at the time of insolvency opening, we decided that we wouldn't have classes of creditors. I'm not a big fan of this part of our bankruptcy code, because what it means is, I mean, it works well, but it doesn't sit logically. What it means is a dollar of debt is a dollar of vote in the committee of creditors, regardless of whether you're secured or unsecured. So your ability to influence the committee of creditors is determined based on how much debt exposure you have as a financial creditor in the company, regardless of whether that is secured or unsecured. So therefore, in most situations facing insolvency, the game becomes to accumulate more and more debt so that you have a greater outsized say in approving or rejecting resolution plan. Those would be some of the key distinctions between how we operate and how the US Chapter 11 operates.
That's very useful. Thank you very much. And I like your analogies, Ashwin. Sudita, is there anything to add to that from your side?
No, I think Ashwin has covered
Okay,
everything.
perfect. In that case, I've got a question for you, just more practical question. Can you clarify for me the actual and practical impact that the IBC has had on the ability to underwrite private credit in India?
Right. In fact, I'm also seeing one of the questions that has come from the audience. So I'll probably just raise that because I think my answer addresses some of that as well. So the question from the audience is that we also observe that the resolution process gets greatly delayed owing to differences between financial creditors. Diverse perspective or commitment to process and procedure also delays resolution. Wanted to invite your thoughts on this, right?
Mm.
So Christian, I'll answer your question and answer a little bit of what's there.
Okay,
So
perfect.
I think the first thing, from the creditor's point of view, is that it's not a coincidence that private credit in India has also boomed a lot ever since the IBC was enacted. So previously you had the NBFCs and the foreign banks doing some of this, but now you see a whole lot of private sector participants using the CAT 2 AI structure who are actually doing it, right? And I think that's because we get confidence that enforcement is available through the IBC process if required. And this is not the only thing I should also mention. So we've touched about the fact that there are existing laws, there are legacy laws which are existing, like SURFACE, etc. So while IBC is available to us, we use SURFACE, we use share pledges, etc., which is under existing legal systems for enforcement. But the IBC is available to us as the final instrument available for us to enforce. And when we now do our structuring for trades, and here I refer to the question that came up, we are very cognizant of the fact that the committee of creditors, you need a 66% threshold for approval of a plan. So, when we do our transactions, we like to be the sole creditor simply because we know that if we go to the IBC, we can control the process. The other thing to keep in mind also is that, remember, the threshold for bringing something to the IBC is only 1 crore rupees, right? So I might be a lender which has provided 99% of a debt to the company, but there is somebody who's provided 1% debt and that amount is more than 1 crore, and they can take the company to IBC when I don't want them to take the company to IBC. So as a sole creditor, I get to stop them from doing that. So from a structuring perspective, we would also try and put aside some money to make sure that if there are any legacy claims from even operational creditors, etc., we need to clean up, we can take care of that, right? And we also think about things like, how does the intercreditor work? What do we really want to do out there? Because uh, we've thought about structuring it so that the intercreditor agreement clearly states that uh, neither party can take the company to IBC without the other party agreeing, but that doesn't seem to be enforceable in law. So you might come to some sort of an arrangement in terms of sharing the proceeds received in case people receive money from IBC, which seems to be enforceable. So those are all the things we now take into account when we are structuring, keeping the IBC in mind. Other minor things we'd take into account would be like, where is the registered office for the company? Because all the NCLT courts are not equally, uh, what shall I say, experienced. So we would like to change the office to either Bombay or Delhi. We would want to make sure there's a third-party security provider. We have to make sure we have provided some debt to them as well so that we can take that particular company to IBC. So the way IBC has changed our underwriting is that we are always thinking ahead and thinking, what will we do if this company goes to IBC? And how do we take care of things like the issue that was raised in this question, that if there's a disagreement between creditors, how do we enforce the process, right? So I just covered the first part of it. The other thing, I think there's a second part to it, Ashwin, maybe you can talk about it, is that there are sometimes diverse perspectives, a commitment to process and procedures also delay resolutions, right? Do you have any thoughts on that? I mean, we typically structure around it, but have you seen anything else?
No, I think uh, there is a commitment to follow a particular process. It's a very prescriptive legislation. I mean, if you follow what is there in the UK, the UK is a more substantive legislation. Whatever maximizes value, the administrator has the power to do. In India, sometimes it can be a bit prescriptive, but those prescriptions are designed to maximize value, and nothing stops the committee of creditors to move ahead with a faster timeline, because ultimately value maximization is their value that is being maximized. Also, to the point on financial creditors, I think the question is right. Sometimes we do see creditor on creditor violence in India as well, but that's no different from what exists in other part of the world. I remember, being involved in the Nortel Networks case in the US, where actually the recoveries from sale of assets were completed in, I think, 1 or 2 years' time. But the actual distribution to creditors of a huge chunk of change that had been received took another 4 years. So it's not a problem that is unique to India. It's a problem that exists all around the world. And the new changes to the bankruptcy code, which have just been introduced, says that the bankruptcy court can approve a resolution plan so that at least the debtor from being in intensive care of bankruptcy comes out, begins to function, and the actual payout to financial creditors can be the subject matter of what is determined by courts subsequently. But that again stands tested against the fact that bankruptcy courts will rarely interfere in what the committee of creditors decides is the manner of distribution amongst financial creditors. So haven't seen many instances where that tends to delay things significantly, because ultimately whatever is determined by the committee of creditors stands true. There's also the first question that, look, is the amount in dollars or in INR? So in statute, it's an INR amount. It's 1 crore, which at today's conversion ratio of a dollar is 96 rupees, comes to about $100,000. So the amount printed in the statute is in INR. So the FX fluctuation then has no impact.
Thank you for clearing up that technical point as well. Thank you, Ashwin. My second question before we continue with with the audience questions is on promoter behavior. How the IBC, if indeed the IBC has influenced, and to what extent it has influenced, has the threat of losing control, for example, truly changed the behavior of borrowers, or do promoters in India still find ways to delay or influence outcomes as we've been used to? Question for either of you on, has it really changed India's credit culture, do you think, and to what extent?
Yeah, maybe I'll take that first, and then Ashwin, you can add on if you want. We think it's changed the credit culture quite a bit, at least when we interact with promoters. We see that their attitude, their behavior, their approach to everything is quite different. I guess it relates somewhat to what Ashwin referred to earlier about you need to have a hell to appreciate heaven, right? So when you have the threat of hell hanging over the promoter, they tend to behave a bit better. Um, I think the biggest concern that promoters now have is about losing control. And this is not just about the financial loss. There's also a psychological impact of being pushed out of the company that you probably have spent many years building up, where you know all the employees know you. There's a psychological impact of being literally kicked out of the management. And then you have this interim resolution professional or resolution professional who comes in, who starts running the company. So I think that impacts the promoters quite a bit. Uh, there's the fact that they also brought in a change in the law which prevented erstwhile defaulting promoters from trying to get back into their own company. Also changed the stake a lot. So previously, before the law changed, I thought people thought it's still okay. I can bid for my own company and get it back. But now they're pretty sure that they can't do that. So I think both the threat of financial loss, the psychological impact, the fact that they know that they can't get back into the company has an impact on promoters. And we are seeing this in strange ways. Like now, when we structure trades, like we are structuring transactions keeping in mind as to what happens when it goes to IBC. The borrower is also thinking about as to what will happen when things go to IBC. So it's like chess, right? In chess, sometimes the threat of the move is far scarier than the actual move itself. So we are in that situation now. So we have the borrower come in and tell us that, uh, yes, I will give you a personal guarantee, which backs up this corporate loan you're providing. But they know that under the IBC process, if you provided a personal guarantee and the corporate goes into the CIRP process, the personal guarantee also becomes part of that. So the individual gets drawn into the process. So now they will come in and tell us that I will give you the personal guarantee, but it'll only be me. My father, who also used to run the company previously, cannot give you that PG because I can't afford to have him going to court, right? He's too old for this, or my wife will not do this. So it's changing people's behavior. And I
Right.
think the threat is a very credible threat that people are taking into account. Ashwin, I don't know whether you want to add something to that because you've been on both sides, right? Borrower and lender.
I mean, I think it has made a big difference. Sure, the pendulum swings as it does in any jurisdiction. So in the initial part of the IDC, it was very, very creditor friendly. Um, I think over the course of time, the pendulum has swung maybe a little bit more towards the middle, but still very firmly in favor of financial creditors for the reasons that you mentioned, that you stand to lose control of your company. No doubt, you should expect the Indian sponsor to fight tooth and nail and fight in court. But I've also seen a change in behavior of judges. They are also less reluctant to sympathize with a defaulting sponsor. So both the referee and the other side player, there has been a perceptible change in behavior where there has been clear default. I've certainly seen that.
Hmm. Interesting. Thank you. Thank you for that. Couple more questions from the audience this time. Um, there's a question on how creditor controlled is the IBC in practice. Now, I think you already touched upon that comparing earlier with the debtor in possession model, but the question, I guess, is how much influence do lenders actually have once a case enters the process?
So I can take that, Sudipta, first, yeah, and maybe you can come in. It's definitely a creditor in controlled mechanism. Who The insolvency professional is appointed by the financial creditor who files for insolvency opening. So you get a say on who the insolvency professional is. That's a big say. Of course, the insolvency professional is independent, governed by his or her own statutory duties, and will be held to account for any misconduct by the regulator. But you do get a say in appointing the insolvency professional, who is essentially the board of directors of the company during this insolvency process. The committee of creditors can replace that person, and that ability to hire and fire an insolvency professional gives the committee of creditors an important sway in an insolvency process. Not entirely, because the insolvency professional also has to maintain one arm distance and statutory duties. So that's fine. But then at each level and each limb of a process, the committee of creditors plays a very important role. As I mentioned, the insolvency process is effectively a M&A process because the incumbent is out. So you need to run a process to invite bids and sell the company. So from who is an eligible bidder, what should be the evaluation matrix against which bids should be evaluated and scored, which bids should be taken to the next round, the negotiation of those bids, the negotiation of the resultant resolution plan, which puts more flesh on the bone, and the final approval of the resolution plan. Each one of these steps is run and finalized by the committee of creditors. So these are critical steps. The
Hmm.
insolvency professional is a facilitator in this process. The insolvency professional has a duty to maintain compliance with the statute. So again, process oriented, be fair and equitable, make sure that the process is fair. But the key decisions and the actual approvals are all taken by the committee of creditors. So absolutely critical role.
Hmm. Thank you. Thank you. Uh, an investor question. What does this all mean for global private credit allocations? Should LPs think about, how should LPs think about India's risk-adjusted return profile relative to other EM credit markets? I think I'll give that to you, Sudhita, if you could
Yeah,
address that.
that's quite an interesting question. Uh, I don't know whether a lot of LPs who already allocate money to Asian private credit funds know that maybe anywhere between 30 to 50% of the money is actually going to India already.
Hmm.
So what's happening is that in Asia Pacific right now, India and Australia are the largest markets. So you ask anybody who runs a private credit fund out of Hong Kong or Singapore, and they'll tell you that 30 to 50% of the book is India. And so the two biggest markets, India, Australia, and everything else is Indonesia, Vietnam. So people already have substantial exposure to India. And if I'm an allocator sitting in the US or in Europe, what do I really care about? Uh, as an allocator, I would think there are three main things that are important to you. Number one is capacity, as to how much money can I actually deploy. Number two is what is the kind of risk that I'm taking? And three is what is the kind of returns that I'm getting. And two and three are mostly go together, right? It's risk adjusted return. So we just talked from a capacity perspective. I think you started off your discussion talking about the credit penetration in India. So India, we know, is now a 4 trillion economy. I mean, maybe fourth in the world or sixth in the world. That goes up and down. But from an economy perspective, it's substantially large. It's a $4 trillion economy. And credit penetration is still very poor. It's very poor compared to Brazil, even comparable middle market, I would say middle power countries. Uh, Private credit as a percentage of total credit is very low still. And I think the Reserve Bank of India has done some studies on this where it talks about what is the opportunity in the middle market for India, because that seems to be a pretty underserved market. And that runs into billions and billions of dollars. So there is substantial capacity available in terms of wanting to deploy money into India. Then we come to the risk return perspective. One of the things has happened in Asian private credit, and this predates the GFC, right? When we used to structure transactions back in 2005, 2006, it was always collateral heavy. It was always cash flow based. It was always covenant heavy. So even when we do transactions in India today, you have LTVs, which we say we should not be more than 50%. So two times coverage on security. And these are secured. This is security, which is in the form of fixed assets, land, building, unrelated assets, right? There is also cash flow coverage, debt to EBITDA ratios. And we put on covenants saying that your debt to EBITDA should be X. You should be able to achieve certain operating parameters. You should bring down your debt within 1 year by selling off certain assets. If it's real estate, then it's linked to certain occupancy ratios. So those standards have been there for many, many years. And unlike what's been happening in the US, where some of these standards have got diluted over the years, as as people have been desperate to lend money, that underwriting has not been diluted in any way. So from a risk perspective, I think people are still doing the right things when they're lending money. And from a return perspective, I think it's still you're making high teens dollar returns, 20% plus sometimes. So from a dollar perspective, gross returns are still quite attractive. So if I'm an allocator and I'd say I definitely want some sort of diversification, right? I definitely need to do emerging markets. I definitely need to do India. And one last point I think I would mention on this is that a lot of lending that happens in India is actually directed to the company. A lot of lending that you happens in the US is basically sponsor financing, where you are basically lending money to a sponsor to acquire some IT company or some
Hmm.
technology linked company. We know that the value of whole lot of those are changing because of the AI boom, right? So your collateral is not worth what it used to be. You don't really have those kind of risks in India. So if I'm an allocator, I would say, yeah, I need to take a serious look at this.
Hmm. Sounds quite
And if I
enticing.
can,
Thank you. So please, if you have something to add, Ashwin.
yeah, Christian, I just wanted to add that one of the ways, and perhaps a very big way in which the IBC has played into this macroeconomic picture is that unlike earlier laws, which were sometimes available to some creditors, available to other creditors, and in several instances, not available to foreign private pools of credit capital, the IBC makes no such distinction. It treats all creditors alike.
Hmm.
Sudipta, I think at the beginning, mentioned a law called SARFAESI, which is a faster enforcement law similar to the collateral directive in the EU. That's only available in most instances to public sector banks in India, private pools of capital only if the debt is listed and traded, and so on and so forth. The IBC is available equally to all creditors, and that has been one of its biggest strengths. And strangely, it's not spoken enough of, but it does make a big difference. And it is no coincidence that the growth of private credit in India has coincided with the Insolvency and Bankruptcy Code being fully effective.
That's interesting. I mean, whilst the IBC may not be the panacea to solving insolvency issues, it seems to me to stack up pretty well and seems quite attractive. And actually, there's another question to kind of follow on from that about what does the next decade of IBC reform look like? I mean, if I can just add to that question, Ashwin, is it still a work in progress? Is it complete? Are there things that indeed you'd like to see introduced, which are still maybe lacking?
It's always work in progress, actually, Christian, and that's one of the encouraging things about it. It tells you that the incumbent administration, in Parliament House here in India, is still focused on this law. They still believe that it's the backbone of their economic reform agenda for India. So there's always improvements going in, which I think is a good sign. Secondly, there are some critical changes that have already been approved by the Indian Parliament just recently. For example, there is a polishing up of the pre-pack regime that we have. There's a new chapter being proposed, just like in the UK, where every decade there will be a new tool added to the toolkit. In addition to the insolvency process, there is a outside insolvency process that's just been adopted by the Bankruptcy Code amendment. While the rest of the world is perhaps pulling back a little bit on cross-border insolvency laws and not implementing the ancestral cross-border insolvency law, in India, the Parliament has signaled that we will at some stage adopt a cross-border ancestral-based Indian version of cross-border insolvency law. That could mean recognition of foreign awards in India, recognition of India's insolvency process in the US. It could mean that it's easier asset tracing. So if you have a situation where Indian assets have escaped to Singapore or escaped to the US, the Indian insolvency professional will be recognized as a foreign representative outside India and get access to the discovery laws of the US, call for evidence, faster enforcement of asset tracing. So these are all things that are very much on the anvil. These are not at discussion stage anymore. It's been passed by the Parliament and rule making is currently underway. So yes, there is a lot to watch out for.
Exciting. Can I just remind the audience thank you. Well, first of all, thank you for your questions, but if you can raise your hand and we'll unmute you and try and make it maybe a bit more interactive for you. I have a question which I guess is really for you, Ashwin. How does the IBC interact with arbitration, especially Singapore arbitration, which has become quite popular in recent years?
So they operate in separate spheres. You have, let's say your bond documents are governed by Singapore arbitration. Any dispute under that bond document can very much go to Singapore arbitration. You may get emergency arbitral awards, which will be enforced in India. But in the meantime, let's say insolvency is commenced. Or to put it differently, as a creditor, you can initiate both. So you may have initiated an arbitration process. That does not stop you from initiating an insolvency process. The insolvency process is a statutory right given to you, so you can initiate both. You can initiate the insolvency process as well. But of course, the moment you initiate an insolvency process and insolvency is opened, then all legal proceedings must come to a standstill because now the debtor needs to be protected. Its assets need to be protected. Individual lender action is no longer in the best interest of the debtor and its assets. So then if you then these legal proceedings in arbitration awards that you have will get stayed and can't be enforced against the debtor's assets in India. But till such time as the insolvency proceedings are opened in India, both options are available to you.
Ashwin,
Interesting.
actually, yes,
Sorry.
sorry, Christian. I had one follow-on question which I had for you here. And I've had a long discussion with somebody who's on this call right now about the same issue. Is that let's assume that there is an arbitration clause in the document, and the borrower takes the arbitration to Singapore because they don't want enforcement. But as a lender, I decide to take it to IBC. My understanding is that the IBC will override the fact that the document says that you should undergo arbitration first in Singapore. Is that correct?
Absolutely. Absolutely.
But when you signed up for the arbitration, those are under some international norms on arbitration, right? Do you not have to adhere to those? Do you not have to follow those?
No, because the IBC is a statutory right protected under Indian statute, and the IBC itself has a non-obstante clause which says, notwithstanding any other law in force in India, this is a statutory right given to a creditor to initiate insolvency. So even if you have an arbitration clause under your document, the creditor can commence insolvency proceedings in India. And a bankruptcy court must hear those proceedings. And if it determines that there is a debt and a default, then it must open insolvency proceedings.
I understand. Sorry, Christian, I cut you off.
No, that's fine. So we have time for one more question. I think you may have touched upon this already, Ashwin, but the question is, does the insolvency process extinguish all past liabilities and creditor claims?
Yes, it does. I mean, this is something that we have grappled with. So let's start with the easy ones, right? So anything that's on the balance sheet is quite clearly dealt with as part of the resolution plan, and whatever recoveries they make, they make. Whatever they don't make, that's extinguished. There are two other buckets where it used to be a little bit more complex, where it's become much easier and clear now. What of criminal liability? And secondly, what of contingent liabilities which are yet to crystallize? I'll give you examples. So criminal liability is, let's say the sponsor has committed a foreign exchange violation in India, and for which there are proceedings against the sponsor as well as the company in question. Well, Indian law has recognized, ever since the time of the Satyam insolvency and criminal proceedings in India, that the wrongs of the sponsor are not the wrongs of the corporate debtor. In fact, the debtor is actually a victim of the wrongs of the sponsor. So in order to provide a fresh start to the company, the wrongs of the sponsor do not continue in the hands of the company so long as there is a change in ownership or a change in management of the company through the insolvency process. So those criminal proceedings can continue against the sponsor, but they will come to a standstill and they cannot continue any further against the company. So that's the second bucket. The third bucket is contingent liabilities which have not yet crystallized. So I'll give you an example. I think during the Obama administration, if I'm not mistaken, in the US, car manufacturers, auto component manufacturers in Delaware went through a Chapter 11 process. And one of the questions was, if you've manufactured seatbelts, what of product liability claims that may arise in future because of a defect over a product that is manufactured today while the company is still in insolvency? Fortunately, we haven't had such a tricky question play out under India's insolvency law. But in general, contingent liabilities which are yet to crystallize are whitewashed in order to provide the debtor a fresh start. Because bear in mind, unlike US, where the incumbent management, who were probably responsible and in control at the time that a defective seatbelt was manufactured, is not the case in India. In India, you by force have to have new ownership and new management. So should they be visited upon by the same wrongs of a product liability, which was probably made prior to their ownership of the corporate debtor, which is now in new ownership, which has come out of insolvency with new owners? So my suspect is if this were to come up before an Indian court, the Indian court would whitewash product liability claims. We don't have a case as such, but all contingent liabilities do get whitewashed.
Hmm. Thank you for that opinion, Ashwin. Um, I think we've covered a lot of ground. I want to thank you, Ashwin, and Sudhita for having made what is a technical subject really, for me at least, clear and concise. I want to thank the panelists also for your questions and for your participation. This is this was a presentation in a series of webinars that we are rolling out over the year related to private credit. So do watch out for the next one. And if the audience has any interest, would like to know what the opportunities there are for allocating to private credit in India, please do reach out either directly to Sudhita Dar or to your respective RMs. And of course, you also have Ashwin's contact details there if you need any kind of legal advice and support. So on that note, again, thank you all for participating. We've run out of time, and I look forward to the next series.
Thank you, Krishan.
Thank
Thank you,
you.
Ashwin. Thank you, participants.